So our panelists for cybersecurity in the maritime industry are Chris South and Eloise Gratton, my partner from our office here in Montreal. Chris is a senior underwriter at the West of England P&I Club in London. On leaving school, as one would naturally think, going into the maritime industry, he joined the Royal Air Force and learned how to fly. He then went on to study business, followed by law, qualified as a solicitor. He practiced before the High Court in London before joining the West of England in 1982 and handled admiralty cases. From 86 to 91, he was responsible for the association's members in South America. And then he was sent to Hong Kong for his sins from 1991 until 1994. Enjoyed it so much he was very much reluctant to come back to the West. Chris led a claims team in London and was responsible for specialist claims, which entailed major casualties worldwide and on-site investigations. And we had one many years ago right here in Quebec, downriver, where we had a ship called the Unisol that ran aground and broke her back in a horrible storm. I've never seen locals empty a ship so quickly in my whole life. Faster than any stevedores could do anywhere in the world, believe me. His casualties that he's handled include major oil spills, container ship groundings and fires, sinking of a cruise ship, and he has also had a fair amount of representation on the international group of P&I clubs and on the BIMCO committee that drafted the GuardCon contract for the employment of private maritime security contractors. Chris is currently a senior underwriter working with teams that cover the club's membership in several countries, including Canada, and he has relatives right here in Canada, in Ottawa and in St. John's, Newfoundland Bay. Eloise, to my right, is a partner here in Montreal, and she's national co-leader of the Privacy and Data Protection Practice Group at BLG. She advises clients from various industrial sectors on legal, practical, and ethical issues relating to information technology, e-commerce, privacy protection, consumer protection, and in connection with their new projects and practices and products. I can tell you very sincerely, Eloise we're very, very fortunate to have her with our firm. She is, some would say, one of Canada's foremost experts. I will tell you she is the foremost expert in this country on the field of privacy and is recognized as the go-to person relied upon both nationally and internationally in the field. She is consulted by both federal and provincial privacy commissioners, as well as the federal government generally. She's published several books on IT and privacy issues, which have been cited by the Supreme Court of Canada in some landmark privacy decisions, judgments. She holds a doctorate degree in law from the Université de Paris and the Université de Montréal, and she has been teaching e-commerce law and privacy and IT law at the University of Montreal for several years. In 2016, Eloise was selected by her peers for inclusion in Best Lawyers of Canada in the field of IT law and ranked by Chambers 2016 as a leading data protection privacy lawyer. And in that same year, she was named one of the top 25 most influential lawyers in this country. So it's a great, great pleasure to have both Chris and Eloise address us today. I think you're going to find this a singularly interesting subject. It's also, I think you'll also find that given technology today, what we're all faced with, it's almost a scary subject as well. Chris will tell you about some things that are absolutely astounding when you have crew members getting their own personal handheld devices contaminated, if I can put it that way. Obviously, I don't know much about this subject, but how that can have an impact on the entire operation of a ship and indeed get into the ship owner's computer system. So I would ask you to give a big hand and a warm applause, a warm welcome to both Chris South and Eloise Gratton.
Good morning, ladies and gentlemen. Welcome to the hangover slot. If it's not your hangover, it's mine. I've been enjoying, and I'm intimidated because there's a digital clock here saying how long I got to speak, but I'm from the analog generation, so I have an analog solution. So, let me see if I can master this limited technology. Okay. Thank you, Jeremy. I don't recognize the person you introduced. It makes me sound as though I actually know something and work, which my colleagues will say is not true. My teenage children, or student children, think it's hilarious I talk about cyber risks because I am completely cyber incompetent, as you will probably see as we go along. Because I venture to suggest the majority of the people in this room are actually cyber incompetent. We are of the wrong generation, most of us. So there's obviously pleasant exceptions. But we're of a generation, we struggle to keep up. But we are the people who are probably the movers and shakers of our companies. And the people who understand cyber are the young, the hackers, the game generators, the guys who work at CAE building simulators. They understand cyber. We're a generation who don't, and that's the problem, because we're the generation who I suppose I like to call ourselves business leaders. We have to set the policies for our companies. But if we don't understand and appreciate the risks, are we going to be driving this very important issue through our companies? Cyber is becoming recognized. There are a lot of seminars, people talking about cyber risks. By the way, I have far too much writing on my slides, so BLG will make them available once Eloise has done my little contract of agency contract on this. So don't worry if you can't read them all, because I won't read them to you. You can read them later, Jade. The point is, cyber is becoming recognized as a threat in the industry. And with due respect to our friends from Maersk I had a chat to earlier, the incident happened this year where they suffered a malware attack on their systems. This caused them a publicly admitted loss of $200 to $300 million. Now, that is starting to be money you have to take really seriously. It affects the bottom line. And that's the bottom line of the major global container line, one of the big two. So it's something that has to be taken very seriously by all sectors. Because the problem is we now live in this automated, integrated, networked, connected world. This is what we've grown up with. Last night I was talking to some guys in the bar, surprisingly enough, a bar in Montreal. But I started work with 9 telex machines. And you talk to anybody who's sort of under 40, you go, telex machine? I look at you completely blank. I used to travel South America for 3 weeks, as Jeremy said. No mobile phone, no email. Hotels were scared of fax machines. Life was bliss. I didn't realize how good it was. And now, I have to struggle to find a holiday where my mobile phone doesn't work. But this is the reality of what we face. Everything's all interconnected, everything's talking to each other. So we live in this cyber environment. In terms of shipping, ships are increasingly computerized. We're going to hear later from Leanne about the move into autonomous shipping, which sounds fanciful. And I did a talk in Brazil, said, yeah, but who would have thought we were talking about autonomous cars? So autonomous shipping. I said, autonomous cars, maybe not in Brazil, because your freestyle driving would challenge any algorithm, but the world is moving forwards. BHP said at a conference recently they would like to have autonomous ships sailing from Australia to Japan with BHP iron ore from BHP terminals, running on LNG, no crews involved at all. The pace of change is coming. But not only are the ships now integrated with all the systems working together, particularly with this reduced manning that's happening down to, the old days people said, 40 ships, there was a steward and everything. 14 ships and you microwave your own food is quite common in European feeder vessels these days. But now ships are now talking by the internet through satellite to the head office, the management office continuously, updating software, the remote monitoring. Lloyd's Register spoke at a conference with me in Rome, and they said you can do complete autonomous control of your ship almost, pre-planned. We just monitor your ship completely. But that means the ship has an opening to the outside world, and wherever, as we come on to it later, wherever there's an opening, there's a vulnerability. As I said, we were talking about autonomous cars. I'm sure you've seen these headlines about, I think it was GM cars that hackers were able to get control of through the entertainment system, etc. If it happens in cars, it certainly can happen in ships, because you would have thought GM would make cars that were hacker-proof. Clearly they didn't. And the other thing that is quite a concern is the potential for what is called GPS spoofing. This is very simple, very cheap. You can actually give a false GPS signal. So the crews, and we grow up now, this is the Game Boy generation on the ships, all they do is stare at screens. You know, when I learned to fly, I was taught the safety device, the best safety device you have is the Mark I eyeball. Look out! But our crews increasingly don't look out. They are the Game Boy. They look at screens all the time. But they might not know they've been GPS spoofed. Now, GPS spoofing is a reality. North Korea, our dear friends in the north there, have done GPS spoofing attacks on South Korea already. It's very easily done. But you imagine if you're navigating the Scheldt or one of these, also Lawrence Seaway, and you're, no disrespect to the Seaway pilots, but you're doing it on, you know, the GPS, watching where you're going, a bit foggy. If you don't actually look out or have more situational awareness, you could easily be spoofed with the tragic consequences. The cascade, this is what really worries the shipping industry, is the cascade. One part of the industry infects another part, because quite often now you find the ship managers, the ship's agents, the lines, the ports, they're all interconnected, they're all exchanging data. So an infection can get in the system and spread. And we really don't know where liability stops if you are the person who introduced the virus. I think you have to now increasingly look at your contracts, because contracts quite often have cyber-related clauses. You may be required to meet certain cybersecurity standards. You may be told that you have to indemnify your counterparty fully for any infection you introduce into their system, but conversely, they are not going to be liable for any infection they introduce to your system. So be aware, look at the contracts. Cyber risk too big to cover. The Lloyd's market, I can tell you, is scared to hell of cyber risk, because the market doesn't understand what are the consequences, how far can they go. As you said, Maersk said they lost 200 to 300 million. But imagine if you're a Lloyd's underwriter and you're underwriting power stations or power networks, and cyber risk get in there and the power grid collapses. What are the potential liabilities? So that the insurance market is genuinely scared of cyber risks. Now, last year, and a lot of people didn't even notice this, the IMO, the International Maritime Organization, published guidelines on cyber risk management. So this is a good starting point for our industry, because whilst it is directed at ships, they actually say the whole industry needs to start looking at it. And I'm sorry I'm racing, but I'm watching the digital clock here. I might cover it up again. The guidelines are quite good in that they're fairly simplistic and point to 5 stages, 5 basic stages of looking at your cyber risk protection. First, you clearly have to identify what are your systems, what is your data that's vulnerable. You need to identify it. So you have to start looking at your own systems first to see what are the vulnerabilities. You then obviously have to build in protection. You've identified the vulnerability, now you've got to protect it. So you have to put in, say, protection systems, software, checks. You need to be able to detect if you've got an attack, a virus. There's no good saying we've got wonderful systems, etc., but you don't know you've been infected. As we've seen with some of the massive data breaches, companies haven't realized that, oh, somebody's stolen all our data. It's a failure of the system. I mean, I will talk in a minute. One of the great vulnerabilities is somebody in your office downloading confidential data. Now, I know some companies and banks have introduced systems whereby any particular portal, say USB port, if there's an excess data flowing through that, it triggers an alarm. Is that somebody downloading data to steal? So you need to think about that. So detection is nearly as important as protection. You then clearly have to be able to respond to an attack or to a problem, and then you need to be able to recover. So 5 simple stages. Now, in the shipping industry, this becomes even more important, because the IMO this June passed a resolution saying that cybersecurity management becomes part of the ISM code, your safety management system, and it comes into force on the 1st of January 2021. So it is becoming law in due course, and it refers to all stakeholders. Now, one of the problems we all have is the guidance. There are 2 very good guides, I think, as a good starting point of these 2. Now, the Code of Practice Cybersecurity for Ships was literally published about 2 weeks ago, and it's been written by the Institute of Electrical Engineers. it's actually quite good because I don't understand it. Therefore, I think it must be quite clever. Because I kind of work out, if I can't understand it, probably he's doing quite well. But if you want to say, oh, where do I start? Pick up one of those guides and have a look. I think they're a good starting point. One of the problems we have is we all use good old Microsoft software. Except I know some people in the room will be rabid Apple fans, but basically most systems in the world use a Microsoft-based software. The problem we have is this software only is supported for a limited period of time, because of course Microsoft want you to buy the next update. That's got to be their product model. If they sell you something and never change for the next 100 years, they're out of business quickly. So you're all using software that has a limited potential lifespan. The problem is we're all building ships that might last 30 years. So the software has an average, say, lifespan of, let's say, 14 years. That's the lifespan in which the software is supported by Microsoft, but the ship's going to last double that length of time. But of course, you didn't build your ship on the day that the software was released. So you build your ship probably with software that's going to be out of date before the ship's even launched, possibly. And that's, again, one of the problems. How many of shipboard systems are updated, rebooted to Windows 10 or what have you? I'm not sure it happens in our industry a great deal. Vulnerabilities. I'm not really interested in hardware failure, the disk fracturing, or the badly written software. This is meant to be cybersecurity talk. So you have the accidental loading of malware, virus, whatever you like to call it, in the office or on the ship, or deliberate. It could be a deliberate attack on board by a disaffected crew member or in the office. And then, of course, there's the external attack, the hacker attack. What I like to say is wherever you have access to a system, you have a vulnerability. Your access, your USB ports, your internet connection, what have you, is like your front door. And the bad guys are out there want to kick down your front door and rob your house. So you've got to think, wherever there's access to my system, I have a vulnerability. What do I do to protect myself? When I was sort of trying to educate myself in cyber, I've read several things. So these, we all have one in this room, I guarantee, amongst the most dangerous things. We all download apps. They may not affect your phone, but there's a lot of apps out there that are on people's phones that are potentially dangerous to your computer systems. They're malware. A lot of phones, 40% possibly of Android phones, have some form of malware on them. You plug your phone into your computer to upload pictures or charge it. You are potentially opening a door to the malware to get into the system. And that's quite scary. Because any access point in our office, we're a paranoid company. In our hanging PCs, every USB port is physically disconnected, so we can't load software. If I turn up with one of these saying, "Oh, BLG's give me this," I have to have it run through a standalone computer, not connected to the office system, not connected to the internet, that just has the most up-to-date antivirus software. So lots of people out there attacking, hackers, phishing, lovely word, people just randomly sending out emails with viruses on them, or spear phishing, targeting your company because they know something about how your systems work. And there's lots of motivations, fraud and theft, etc. Lots of people attack. We only got limited time to talk about things. Obviously criminals, competitors, hacktivists we'll come back to because that's quite interesting. It borders on terrorism. And one of your biggest risks is actually your own employees who may be trying to steal data, possibly take it when they're moving jobs. Nothing like downloading all the data of a firm to take to a competitor. In our industry, clone phishing. This is where they set up fake websites. It's happened to a liner company in China. People set up a fake website. You could book your cargo. You pay for your freight. They even ask you, can you give your bank account details in case you've overpaid and we can remit funds back to your account? What happens, the guys turn up at the port, "Oh, here's my container, could you take it to Europe?" And never heard of it. But the day they turned up at the port to deliver the container to the line, they didn't know about it. It's the day their bank accounts were attacked. So fake websites are a real danger, clone websites. FedEx have had a lot of problems with people setting up fake websites to track cargo, so people log in, where's their high valuable cargo, so the thieves can come and steal it. BIMCO, just 2 weeks ago, issued a warning about fake shipbroking websites. particularly, pretending to be from a respectable company, voyage charters, book in, oh, can you pay a deposit for liner out terms, because we'll do, it's all part of the deal. Again, you have to really look and check. Scam, this is one of the classic ones in our industry, everybody's industry. The CEO scam. You get a message from Jeremy to one of his associates, I need to pay my golf club membership today, can you just pay the funds out of the central bank,
You said you would suppress that.
Oh, sorry. But fake email scam, it's a really big problem. We issued an alert because we had various claimants you got notice, can you pay to this bank account? The money disappeared. Not paid by us, by our members. A real problem. And also this year, as an example, the Britannia Club, somebody in Taiwan was sending out messages in Britannia newspaper purporting to be from brokers saying, oh, the Britannia Club's changed its bank account. Can you pay your premiums here? And some people did. The money, of course, disappeared. They still owed the Britannia their premiums. So you need to be aware of these sort of problems. Hacktivism. This is an interesting issue because hacktivism is people who are motivated. They think they've got the moral high ground, and this organisation, Anonymous, the movement, is the biggest one. The problem is hacktivism can border on terrorism, and we'll look at that very quickly. What is terrorism? Terrorism, under the UK law, is advancing a political, religious, racial or ideological. And it goes on to say it's not just the explosion, seriously disrupts systems. Ideological. Is a hacktivist an ideological terrorist? The Greenpeace movement. The people say, we don't want people trading in the Arctic, and they crash your sites. Is that ideological? If it's ideological, it could be falling under terrorism. And if it does, the problem is it takes you into a different type of cover. Now, the international group, we do not have, at the moment, an exclusion for cyber risk. So if you have a P&I accident where cyber attack is involved, you still have P&I coverage at the moment. But we are not war risk, the primary war risk underwriters for ships. The primary war risk underwriters are usually the hull market. We do give ship owners, we do give ship owners war risk cover excess of their primary war risk cover. But in our war risk cover, we have a cyber exclusion by use of or operation of means of inflicting harm of any computer virus. So if it's war risk, but there is a cyber exclusion in the war risk policy. The clubs, for some reason, under biological cover, do give owners cover for $30 million for liabilities to crew arising out of a cyber event. E.g., the owner has a liability to the crew. He can't recover from his normal P&I cover because it is a war risk, but he can't recover from his war risk underwriters because they have a cyber exclusion. Now, the standard clause, and this is the juicy bit, 6 minutes, 52 seconds, is CL380. CL380 is the nuclear weapon of clauses. It's a killer clause. And we're going to look at it very briefly. It starts off, in no case. That is a pretty powerful exclusion wording, in no case. As a means of inflicting harm, malicious code. Important, malicious code. Because malicious is not bad software. It's software that's been written with malicious intent. But CL380 is so powerful, directly caused by, contributed to, arising from a cyber incident. So there's no really proportionality. If cyber was involved in the incident, then it is in no case do you have cover. That's a pretty powerful exclusion clause. And it uses the word harm. Not loss or damage. We're all used to loss or damage as a standard exclusion. Harm goes far beyond it. Harm is a concept that comes really from criminal law. So it's a really powerful exclusion. And I say to everyone who has a ship or in a marine policy, look to see if you have CL380 type exclusion. It's standard in most markets. That type of exclusion. The American clause is about 2 pages long as usual. In England, receipt and release says, thanks for the money acknowledged in settlement. An American receipt and release goes for, sorry, Wayne, but goes for pages and pages. It's the same with their cyber exclusion clause. But they're strong clauses. There are other clauses out there that are in the commercial market. The terrorism form, again, this policy does not ensure, and then goes on to talk about harm, etc. So cyber exclusions are absolutely common as anything in most policies, and you need to sort of root them out and then talk to your brokers about either buying out the exclusion or getting a proper replacement cover. Please don't read this, but this is far too long, but it's another London Market electronic data endorsement that's on policies. And again, this policy says, this policy does not insure, regardless of any other clause. These are really powerful exclusion clauses, and I think you need to be aware that they exist. Now, this is my own little theory. We all know, I'm sure those who are in shipping, Hague rules, the owner has a duty to exercise due diligence to make the vessel seaworthy before the commencement of the voyage. Now, imagine you have an incident that causes cargo lost, and it turns out there was a cyber failure that led to the loss. You know, the cooling systems failed. You're going to have to see, did the owner exercise due diligence? What is due diligence? Best management practice. What is best management practice? I say, as of June 16, they will look to see, well, are you at least following the IMO interim guidelines? It may not have to be part of the SMS system now, but if you're trying to exercise due diligence, the starting point must be look at the IMO guidelines. So I think, you know, it's a reality. Cyber risk and paperless trading, more and more, the international group approves 3 paperless trading systems, and I can only ever remember the name of one, Bolero, because it sounds like a dance. We don't exclude any problems you have with using these paperless trading systems, but, and this leads slightly on to Elias's talk, a lot of them contain very strict data protection because you hold a lot of information. If you breach that, that's not a club cover point. Again, it's a newspaper article, but you know, I'm English, so we always believe the BBC. But there's talk there that if you don't have some form of cyber protection in your company, are you actually not acting as a prudent uninsured, and you may actually be in breach of your insurance? Because these days you can't pretend that you're not aware of the cyber risks, and therefore you should have some form of cyber protection in your systems. Now, the market sells you cyber data risks insurance. It's great. It provides a lot of useful things for you: breach cost, investigation costs, ransom costs. What it doesn't do is replace the policies you've lost. And that's the key issue. So if you have a hull damage, maybe there's a system failure and it leads to a lack of lubrication causing the tail shaft to break because the simplex seals, whatever you call it, is gone. You have one of these policies, wonderful, but your hull underwriter is going to say, sorry mate, CL 380, you're not covered. So you need to be aware, can I buy back the cover? These market policies do not replace the covers you lost. So I'm actually going to crack it almost in time. So computer health, human health, actually very, very similar. We take inoculants to protect against known diseases. Antivirus software protects against most known viruses. But of course, it's rather like Rumsfeld. You don't know the known unknowns, etc. If you remember that wonderful speech, Rumsfeld. We don't protect against all known viruses because we can't, Ebola, etc. The antivirus software doesn't protect against all known computer viruses. So you have to have good cyber hygiene, like human hygiene. And you know, human hygiene, the best hygiene protection you can do besides being super fit and running is just wash your hands regularly. I mean, it's amazing. We had this is a slight diversion, 1 minute, 30 seconds. A cruise ship. Big outbreak of norovirus, you know, the rather unpleasant both ends of the body simultaneously disease. You deep clean the ship, and they have an outbreak again. Deep clean the ship, outbreak again. What they weren't cleaning was the lift buttons. What does everybody press in the hotel, in the office? The lift button. Similar, it's hygiene. Have good hygiene in your computer systems. So there we go, it's the penultimate slide. I'm sorry, it's a hell of a rush. I'm down to 44 seconds. Jeremy said I'd had to buy lunch if I overran. And I'm very mean, as he knows. It's meant to give you a little foretaste of the subject. It's a very wide subject. You need to make sure you have people in your companies who understand. But that needs leadership. It needs leadership to make your whole company aware of cyber hygiene, cyber health. And your insurance teams need to check your policies to make sure that you either have exclusions, if you have exclusions, you buy them back or you buy appropriate covers. But this is the reality going forwards in this cyber interconnected world. there's no escape from this. And the problem is, it's evolving so fast that it's only really either the techo nerd or the younger generation who keep up with it. It's a real problem for all of us, but it's a real vulnerability. Last comment, think of a cruise ship. Cruise ship, and I know Jeremy likes going on cruises. Cruise ship probably has 4,000 passports scanned into its system, maybe 2,000 credit cards. And some of the ships have been operating with a single Wi-Fi net for the ship and everybody. Wow, what a pot of gold to a thief. So be aware. Another company I've talked to, after my talk, they went out into the, oh, the red light, I love this. They went and hired some experts to go into a thing called the dark web, which I'm scared of because, you know, CIA will realize I've been looking at it, but the dark web, and they found plans for ships they had ordered that hadn't even been cut steel. They found the personal email addresses of all their staff in the dark web. So you need to get people in to look at your companies to see how secure you are. Ladies and gentlemen, that's a hell of a rush. I'm really sorry. I've managed to survive my hangover, which is entirely due to BLG. Thank you very much. I hope you enjoy the rest of the day. I'm looking forward to hearing Eloise here, because data protection, it spins out of this, but that's also a massive issue. Look at Uber, 30 million emails, addresses gone and things. Thank you very much. Wow. 1 minute 30, overrun.
Thank you very much, Chris. Very much interested and appreciated.
It's a hell of a rush.
And I'm sure most of the people understood what you said. And I don't mean from an intellectual perspective, I mean from your accent.
Yeah, I'm sorry, no French from me.
And speaking quickly, now I would like you to pronounce after me. Eloise.
Eloise.
Not Eloise.
Oh, I know. Eloise, sorry. Pardon.
I'm not offended.
Those are letters of indemnity. Eloise. Alors, Eloise,
Merci.
c'est à vous.
Alors, bonjour, bonjour à tout le monde. Before everyone gets nervous, oh no, I'm not going to be presenting in French, don't worry. So it was a great introduction to my topic. In the B2B world, a lot of companies don't realize that there's still some privacy risk. When you see data protection, perhaps you say, oh, B2B, shipping, companies, I deal with companies, so why do I need to worry about that stuff? You gave a great example, so I could have not done a better job, you know, scanning passports, email addresses. Everyone has employees. Everyone has marketing databases. Just last week, I was managing a breach. The hacker got into, it was an employee that clicked on a link they were not supposed to, and then the click was asking, it was a phishing email. They asked for his password, he entered the password, so boom, the hacker comes in, hijacks the inbox. So what do you have in your inbox? It was 1,000 emails. Tons of commercially sensitive information, invoices, a lot of email addresses that can then be contacted for more fraud, more phishing, scams. So this is bottom line why you need to worry about that stuff. First of all, in Canada, there's going to be a breach notification, which will be mandatory in some type of breaches. So I'll be talking about that with fines. The risk also has evolved. It used to be, you have a little security breach, you put it under the rug, you try to fix it. Now you have to report it, and there's more and more class actions following these breaches. So I'll be talking about that. And also, if you've seen GDPR and you don't know what it is, I'm going to be talking about that too. So in Europe, they have a new regulation coming into force in May of 2018. Very stringent, huge fines, has extraterritorial reach. So you should know what it is. A few weeks ago, I was in a conference in San Diego, privacy conference, and there was a lot of panels. GDPR would like count down, the amount of days before this new rule is coming. It's like the Y2K of our time. So I'll be scaring you a little bit with the GDPR. No, but joking aside, it's important to know if it applies to you, when it does, and what are the risks. So the plan of my presentation, first I'm going to be talking about cybersecurity, but really from a privacy perspective. Chris has done a great job telling you, the risk with cybersecurity. So it's going to be more of a, what do you do? How do you manage these breaches when they involve personal information? And then I'm going to a little bit of focus privacy class action and what's going on in the global arena. So new risk, I have a lot of slides. I'm going to be going quickly through some of the slides because I don't have enough time. I see I already wasted 5 minutes for the introduction. Quickly, I'm going to go through some of the slides. So recent breaches that affected the security of other businesses. So in the last year, a lot of clients contacting me, they're saying it's very strange. A lot of customers are telling me that people are getting into their account, they're modifying their password, ordering stuff, defrauding them of loyalty points. There's tons of issues, different companies. And then we start realizing, okay, following these breaches, there's more breaches. So what happened there? It was Yahoo and LinkedIn who suffered massive breaches, 2013, 2014. And the hackers had access to email addresses and passwords. So since people use the same email addresses and the same passwords to access other sites, other companies that had no security issues suffered, security incidents following these two breaches. So if you're wondering, at some point, why is, a third party accessing my accounts, my customers' accounts? It has to do with these two breaches. So usually companies have to kind of contact their customers, their employees saying, okay, fix this, change your password, and you have to have in your system the ability to make sure that they're not going to re-enter the same password because people are lazy and will probably do that. On where do we stand in Canada on the issue of data protection? So when we talk about privacy laws, usually we talk about data protection laws, really laws meant to protect personal information, collection, use, disclosure, supposed to be transparent, tell people how you're going to use their personal information. If there's an unauthorized disclosure, you have to, this is where the breach notification comes into play. So where do we stand? Well, in Canada, there's a federal law that applies, called PIPEDA. It applies across the country unless a province has adopted its own law that would have been found as being substantially similar. So far you have BC, Alberta, and Quebec that have their own laws. So bottom line, if you have operations across Canada, you're subject to these 4 laws. If you're not federally regulated, you're not a bank, you're not a telco, when you're managing employees' personal information, you're really subject to the 3 provincial laws. So something to keep in mind. Sometimes clients have an incident in Ontario, pertaining to their employees. They're like, I've nothing to worry about, right? I'm like, yeah, technically, PIPEDA doesn't apply, but it doesn't mean that you don't have an obligation to make sure that you mitigate the risk for your employees. Where do we stand on the global arena? So in Europe, very pro-privacy jurisdiction, so that's why I put Europe in strong protection. US, much less. They, free flow of information. They really have certain laws specific for industries that are high risk, financial services, health services. So you don't need to worry as much except for breaches, and I'll get to that. In a few moments. What is your legal obligation when you're managing personal information? These laws provide a very general obligation. You have to use adequate security measures, taking into account the sensitivity of the information. So what does that mean? It's very broadly worded, technology neutral. So over time, we have case law, findings, guidelines. So we know a bit more what that means. So for instance, you have tons of issues about employees losing laptop. Whoops, had a whole, PowerPoint, Excel worksheet with all my employees' personal information, social insurance numbers. So privacy commissioners are kind of coming in and saying, should have been encrypted. Okay, check, we know that much. So it's kind of evolving also. And if there's a security incident, privacy regulators will look at these 3 things. They'll look at governance. They'll say, okay, did you have proper policies in place, processes, who's in charge? Supposed to have someone in charge of managing privacy issues within the organization. The second point is necessary information. You're not supposed to collect information that you don't need, and it's always an issue. Marketing databases that include date of births. Why do you need date of births for marketing purposes? Maybe you need an age range if you want to send them a birthday, a notification. Maybe you just need the birth date and not the year. As soon as you have that full date of birth, it changes the risk completely, and then sometimes, if there's a breach, you need to notify. If you also are outsourcing, transferring, payroll or something like that, payment processing company, you need to only provide them with what they need to provide the service. And sometimes it's easier to send the whole client, whole customer's file, whole employee's file, but you need to kind of do the exercise of what do they really need for that services, because if there's a breach, this is what the regulators will look for. They'll say, why did you transfer that information that was not needed for the service provider? And also, if you're outsourcing, you need to have stringent security provisions in your contracts, and you need to consider cross-border issues as well. Talked about that. So I said over time, we've had some case law. So last year we had that interesting decision in the Ashley Madison case. Anyone was involved in this case? Just waiting. Sometimes I get a few hands. So a lot of companies, were like laughing. Very different business model from what everyone does. So people didn't feel, interested in this case and the lessons learned from the finding. But it was actually an interesting case. So for those of you who don't know what Ashley Madison is, I didn't know. It's a website for promoting extramarital affairs. So they had a big hacking, and then there was an investigation, a joint investigation from the Canadian Privacy Commissioner with the Australian Privacy Commissioner. And at the end of the day, they had a lot of issues. They issued a lot of lessons learned that are relevant for all kinds of industries. So of course, in that they didn't use adequate security measures. Somebody hacked, and so on the technical side, there was some lessons learned. They were keeping information for too long, and that's always it's always an issue when there's a hacking. Why did you have that old information? So in this case, they said, why are you keeping your members that are no longer members that have terminated their membership? They said, well, sometimes they come back, so we want to be ready and be able to service them. They said, okay, well, then they started digging. They said, well, how often do they come back? They said, well, usually 50% of people come back. Within what kind of period? 30 days. Okay, then why are you keeping this data for 2 years? So that's the kind of thinking that they have if there's an incident. Why are you keeping the data? And sometimes you have a legitimate reason to keep it, but something to keep in mind. They were collecting email addresses at the time of registration without validating them. So in the database, there was a lot of fake accounts, fake names, fake email addresses. So they got some pushback from the privacy regulators. Said, why are you keeping these email addresses? Why are you even collecting them if you're not validating them? They could be fake, and in some cases, they were fake. So they said, well, we don't want to confirm because it's a sensitive type of business model. Maybe, the wife will see the confirmation to the service, so we're not. They said, you can't do that. If you're collecting it, you need to validate it, because then imagine there was a class action lawsuit that followed the incident. So you had one class is all the members that were promised that their information would be held secure, and then it wasn't. But yet all this other class of people who ended up in that database who had nothing to do with the service. There was a young politician from Ottawa. She was like, I'm 24, I'm cute. Why would I be on that website? And people believed her. It was clearly someone who had used her email address. Lack of transparency. So on the right, you see the security seal that they had. That this is the actual security seal that they had posted on their website. They said that's create a false sense of comfort for companies, for individuals to sign up. Secure, trusted, there's a medal. They said, don't do that, If you're trustee, you're a member and you're using trustee, perhaps it's okay to use their logo, but don't make up some fake seals, because then people will sign up with a false sense of comfort. And the last one, which is relevant, you cannot absolve your legal obligation under data protection laws, under PIPEDA. So you can't say in your terms of use, when you do business with us, you know, we can't protect your personal information. It's an obligation that you have in the law, and you can't contract out of it. So when there's a security incident, privacy regulators will look really at three things. I talked about governance. Quickly, I talked about data minimization. They'll look at technology. Were you using adequate technical standards? So in many cases, clients will say, is this okay? I'm like, well, it depends. You know, sometimes I know the current standards, but it's really up to the IT expert to say, yes, this is the state of the art, this is the current standards that everyone uses. So what's an industry standard? Well, they're going to look, you know, who else is using it, the reputation of the entity issuing it. You know, is it an ISO standard? That's pretty, you know, usually it comes with some reputation around it. Is it difficult to implement it? How expensive was it for you? So they'll take into account the size of the organization, the sensitivity of the information that is stored, and determine, you know, that, you know, you were using adequate security technical standards or not. One of the first privacy breach, it was the TJX breach in 2007. And at that point, it was a joint investigation between the Federal Privacy Commissioner and the Alberta Privacy Commissioner. There was a database that was hacked, and they said, you're using outdated encryption. So it was a bit technical, but I put the relevant provisions of their report. And a lot of technical experts were making fun of this report, because by the time it came out, that standard was also a little bit outdated. So it goes, you know, it goes by quickly. So important to have an IT person that is knowledgeable and up to date on these issues. So every year you have Ernst & Young and IAPP, which is the International Association of Privacy Professionals. They issue a global document on privacy governance. So they survey tons of companies across the world, some Canadians saying, what are you using? Where are we at? So it's interesting to benchmark yourself against other businesses. What kind of security standards were required from vendors when you're outsourcing? And ISO came first, you had PCI, you had SOC 2 privacy, so that's an interesting chart. We don't have the 2017 report yet. And they'll look at culture, corporate culture, and we'll talk to that in a few minutes, but usually I would say in 79% of the cases, and perhaps that will change, but looking from the privacy class actions, the cause of the security incident is internal. It's an employee that clicked a link, that didn't realize they couldn't send that data, that decided to commit some fraud, you know, and sell some data. It's very snooped on data that they were not supposed to. 79%. So more or less, it gives you an idea. It's very often an internal issue. So usually the privacy regulators will say, did your employees receive privacy and security training? Were they aware of policies? How did you disclose these policies to them? Were they easy to understand? So that's the kind of questions that they'll be asking. There's a lot of additional cybersecurity framework. I'm not going to get into it. You have a whole list, and I think the slides will be made available to you, so you can go to them. Ransomware, tons of them in the last month. I've had 5 cases of ransomware in the last month. I've been in that space for quite some time. It's the most amount of ransomware files that I've received in a short period of time. So it's raising a flag, you know, right before Christmas. A lot of retailers also may be at risk. Usually guidelines say don't pay the ransom because it will encourage the industry, because it's a business, to launch more attacks. Still, in some cases, clients say it makes business sense to pay them. So I have a colleague from Vancouver, and we both manage these types of files, and we also work together, so we're comparing notes. And the ongoing rate in the 5 cases that we had in the last few weeks, the ransom, the fraudster was asking for $250,000, it was between $250,000 and $300,000. And you have to pay in Bitcoins. So yes, you know, do you need an account in Bitcoins to be able to deal with that? Maybe not, but one client, I had a conversation with him the following day. His operations were paralyzed, the website was down. He said, I can't pay my employees, nobody can work. It's as if there was like a major fire. So I thought it was an interesting analogy, you know. Nowadays, everything is digital. People work on their computer. So if your data is hacked and it's encrypted and you're locked out of your data, what do? You know, so very important to back up your data, all this to say. Upcoming security breach notifications. So I talked about data protection laws. Where we stand in Canada, Quebec perhaps is a bit more stringent on some issues. On breach notifications, yeah, we're not quite there yet. In the US, almost every single US state has its own breach notification law, very strong on that issue. In Europe also, with the upcoming GDPR, I'll be talking about that. In Alberta, it's mandatory. In Canada, it's coming. We've seen the regulation. It's still being negotiated, but any day, probably in the next coming months, maybe Q1 2018 will be an obligation. Quebec and BC, a little bit behind. It's not yet mandatory. This being said, in many cases, you still want to notify people if they can help themselves, right? If it involves personal information, it involves your employees' SINs, passport numbers, you need to let people know so that they can fix that, change their passport. If they don't know, then this is where they're subject to, you know, identity theft and fraud and so on. So mandatory breach notification coming up under the federal law, under PIPEDA, with fines, potential fines. Also a record-keeping obligation. So when you have a security incident, you're supposed to keep the data. For now, they're negotiating. They say at least 2 years. The privacy commissioner is saying, no, we need 5 years, so we'll see where they land. They say we need a longer period to be able to address systemic issues. You know, if you have a lot of breaches in a short period of time, we want to be able to say, okay, show me your record keeping, because I want to see what else, if you've had similar breaches in the past and you did not properly address them. So when you're managing security breaches, first thing to do, contain the breach. So usually I get a call and I'm like, okay, did you close the access? Yes, we're in, you know, right into that. You need to send a litigation hold. It doesn't have to be exactly a litigation hold, but you want to make sure nobody will be deleting stuff, you know, especially from your IT department. I've seen that. People delete stuff, they block access, and then you have no data. So it's more difficult to conduct your investigation and see what went wrong and fix it if you don't have that data. Legal privilege strategy. More and more, we have clients asking us, the law firm, to retain the cyber forensic expert for legal privilege purposes. So we'll hire the KPMG, Deloitte, some of the big 4 security firms, and we'll deal with them so that you can have your report under privilege. Do you need to notify third parties? Of course, right away, your insurance company. If you have coverage, so in some cases, your business partners. Law enforcement, they'll do nothing. And they'll do absolutely nothing. No, they don't have the resources, but they're interested. But then 2 things to keep in mind when you it's good from a PR perspective, you know, if you're going to be notifying your partners, customers, individuals, employees, to say, you know, you're positioning yourself as a victim. But sometimes they get bribes, you know, for large breaches, they get bribes. Some reporters may come out. And also sometimes the police say, oh, okay, you have a cyber forensic expert. Can we see the report? You have to make sure that you're not going to disclose the report and lose that privilege. You're supposed to have a breach incident response plan already in place. You're supposed to know who your internal core team is and who's your external team. Can be legal, cyber forensic, PR expert, social media expert. You need to have that in place by now. And then you need to determine, am I liable? Kind of going through, you know, what went wrong, because quickly you're going to need to notify affected individuals potentially and regulators. So you need to get, you need to kind of position your file like, this is what went wrong, and we fixed it. So this is usually how the assessment takes place. When do you need to inform individuals? If there's a real risk of significant harm for them. So sometimes it could be embarrassing information, if you employee information, their salaries, their evaluations that could be considered as sensitive. On the right side, I put objective harm. If there's unique identifiers that could be used, as part of an identity theft, fraud, credit card numbers, signatures, email addresses. In some cases, I have clients saying, oh, marketing database, name, email addresses. What's the big deal? Well, depending on the context, sometimes it could be subject to phishing, so it's not it's something to keep in mind. Reputational risk for the organization, I'm going to talk about it when I talk about class actions, because I see time is running. So when do you notify? As soon as possible, but sometimes these investigations do take time. So you need to kind of make sure that when you notify people, you know that they've been affected. Because I've seen clients go back twice, 3 times. You look stupid, so you want to do it once, you want to do it right. If it takes a few more days, then take it. Make sure when you reach out to customers or employees, you're clear about, we've been diligent, we've just received the results of that cyber forensic expertise, so we're now able to notify you. Direct notification, ideally. The new regulation, they're saying by email only if consent was obtained. That's weird. In very many cases, you're going to be notifying people by email, especially if that's your way of communicating with them. In some cases, it's too expensive. You don't have up-to-date information about your customers, in which case it's going to be an indirect notification. The content of the breach, you can read it. One thing so the OPC wants to know everything about your security measures. You have to keep in mind that they may be subject to access requests. So whatever you tell them, you want to give them enough information for them to say, okay, they got this under control, and not conduct an investigation, kind of close their file. You don't want to give them commercially sensitive information, because then you're gonna, if they're public sector entities subject to an access request. Every year I have clients saying, okay, what is this? I'm like, yeah, they've been, there's a reporter every year that asks the Federal Privacy Commissioner, give me all the, the breach notification that you've received in the last year. So we negotiate them. I have like 10 clients calling me at the same time when we negotiate them. When you notify affected individuals, sometimes just telling them, our marketing database was hacked and included your email addresses, good luck, is not enough. They don't realize that the risk is phishing, and how do you help yourself from phishing scams? So usually it's supposed to help the individual understand what is the risk and how they can mitigate that risk. If it's a large breach, call center, they need a script. You want to make sure they know what to answer when people call. It's they have their story straight, basically. In some cases, companies will offer credit monitoring if there's a risk of identity theft or fraud. And then we talked about that. And then managing the after breach in Alberta, the Privacy Commissioner will issue their finding. They'll post it online. So I usually inform clients, but some of them, when they report the breach themselves, they get surprised, like, oh my God, this whole incident decision is online. I look stupid. No, you don't. There's hundreds of them online. Everyone is subject to breach, at some point in time. The good news is that, I'm not going to say there's no reputational damage, but it happens to everyone. So risk, how these risks are evolving. I have 2 minutes. I'm going to try to do it very quickly. Can I have 3 more minutes, perhaps? Maybe we can. Maybe 3. Maybe 5 minutes overall. Some statistics. So it used to be, I have a breach. What's the big deal? I'm going to tell people, and perhaps I'll lose a few customers, and maybe reputation, maybe my stock will drop a bit, and it will go back up. Publicly traded. It's not the end of the world. There's a new risk now, and it's privacy class action. So I would say it became a trend in 2010. In Ontario, there was a recent privacy tort in 2012. So right that year, we had like 16 cases that followed. There are 61 privacy class actions across Canada. Some of them are following a security incident. The hacking began in 2013. So the real hacking cases, there's a security breach. Usually, you have a large security breach, you notify people, or it comes out, you'll get a class action. It's almost expected, unfortunately. None of these cases have been heard on their merits. 10 have settled, 12 have received a certification. It means that they can move forward and, a court will hear whether there's a basis for any damages. And in 9 cases, the certification was refused. You have it by industry, if you're interested. You have it by claim type. You see the hacking, we're at 18. So these types of class actions, security class actions are more recent. I talked about hacking since 2000. More claims, most of the claims relate to employee conduct or misconduct. So something, again, to keep in mind. Lessons learned from recent certification. That one is interesting. It was the Target breach that took place in the US, and a Quebec court has allowed a Quebec class action for this US breach. So that's interesting. We'll see where that goes. In these other cases, what's interesting is that the court kind of changed their mind on, it was the same file. It was a laptop that was stolen, lost or stolen, a lot of financial information on that laptop. So people receive credit monitoring. So what's the harm at this point? What more can you do as a business? So in one of the cases, the court said nobody was the subject of identity theft yet. So what's the damage? What are you claiming? That every month for the next few months, you have to double check your financial statements to make sure there was no fraud. It's normal to do that in our day and age. It's easy to do it. You have access to the internet, to your banking account. So there's no claim, there's no harm. I'm going to refuse the certification. But the same new plaintiff, it was a subject of identity theft. Very hard to make the connection that it was linked to that incident. Nonetheless, the court kind of had a change of heart on this issue and said, "You will give." In French, we say, "On donne la chance au coureur." We're going to let them. Be heard by the courts, and perhaps they have a certain claim that could be founded. You can read about the People's Trust decision also that was certified in BC earlier this year in terms of how, bottom line, very low threshold for certification. Recent settlements, 2 in 2016. Lozinski case was the Home Depot case. You can read. More or less $500,000 for which they settled. $5,000 if you could prove that you were the victim of identity theft. In the Evan case, kind of similar. $444,000 to class counsel. Other than that, it was $7,000 that was issued. But again, you need to prove that you've sustained some harm more than being concerned about being the victim of identity theft or having to check your financial statements and accounts. This one was the Walmart. This one is interesting because it happened, it was a service provider that had a hacking, so they had to settle that. Class counsel are not getting rich doing these cases yet. In many cases that settled, they need to offer credit monitoring. Few minutes on GDPR, very quickly. Evil law in Europe coming into force. No offense. But you're going to have a similar law too. Anyways, okay. So it applies to, as soon as you're offering goods or services to European residents, whether or not a fee is charged. So if you have a website you're selling, making goods available, or if you have a website that is monitoring the behavior online behavioral advertising, so extraterritorial effect definitely. Accountability, you need to similar than what we have under Canada. They have special categories for sensitive information, and the whole consent concept is different, and I think they got it right. So they're saying when you get consent from individuals, it has to be a real consent, so it has to be optional. Much more stringent than what we had, because people are consenting right, left, and center, and they don't read privacy policies, they don't read consent forms. But you don't need consent if you're collecting personal information and it's core to your main service. So they're kind of giving a break for anything that's legitimate and core to your main service, but for any other uses, you need to get real consent. The breach reporting within 72 hours, that's way too short. I don't know how companies are going to manage that. Same threshold when you need to notify individuals if they're the real risk of significant harm. And that's where it hurts the fines up to 4% of the business's annual worldwide turnover, or 20 million euros. So we'll see how they enforce it. I don't think we need to panic yet, but still need to kind of get ready. And then they're going to be assessing every single country to see if we have adequate laws. So we passed the test. Canada passed the test 10 years ago. We'll see if we pass the test again this time. And all this is relevant as well because it's creating pressure to Canada to incorporate some of their provisions to make sure that we pass that test. So that's it. A few. I think was I on time or did I?
Very good.
Very good. Thank you.
Now, from the outset, I've said that I'm absolutely ignorant about this subject, and I repeat that. But I'll tell you, for anybody that thinks that this happens to somebody else, I'm an example. And it was my credit card, my email, all that information you give from checking into a hotel, and it was a major chain when I was up in Toronto about a year ago, and I received a notice about 6 months later saying, we've been hacked, all the information has been taken, and so I've had to be very careful about my own personal data. But of course, you know, with my email address, it was my office email address. Thank goodness that BLG has an excellent system. I can assure all of you about that. But it can happen to any of us. So this has not come some kind of, excuse the expression, artsy-fartsy idea out there that can only happen to some people. It can happen to everybody. Now, if there are any questions, and perhaps I would ask Eloise just to touch upon this a little further on the last subject, because any companies that are based in Europe under that legislation, as I understand, there's a trickle-down effect for their Canadian subsidiaries, so that indirectly the companies here come under the purview of the legislation in Europe. If anyone wants to know anything more about that, you can put your questions to Eloise. But right off the bat, are there any questions for either Eloise or Chris?
I have a question.
Yes, Guy, go ahead.
I think there's a direct correlation between...
Hang on, Peter will just give you so everybody can hear.
I think there's a direct correlation between all these threats and the efficiency of our access to data. A direct correlation. And we desire this efficiency. We want this immediate access to data. So, to me, it's sort of obvious that we have to make data less accessible with things like encryption, PKIs, and so on. And that is basically what we're facing, which businesses, well, I personally wouldn't like that because data is less, it slows things down. We want everything sped up. So I'm thinking that, but you didn't allude to, for instance, encryption as how that features in the solutions, possible solutions. So that's perhaps a point or two I'd like you to comment on. Thank you.
Sure. Does everyone have a different mic? It's good? Talking loud enough in the back? Yeah. Okay. So encryption is really considered as a security measure that should be used every time, you know, the information is in transit. Even if you want to limit access, you know, and it's a server, and it needs to be encrypted, even if it slows things down. The question that I often get is, in some cases, there is restriction to transfer information outside of the country or to a service provider. They say, if it's encrypted, it's okay, right? It's anonymized data, it's encrypted. It's not considered anonymized under data protection laws. There's always a key somewhere, and you're allowed to, there's somebody somewhere that can match this data, you know, decrypt the information. So it's a security measures. It's important to have up-to-date, you know, encryption technology, but it's not because the data is encrypted that you can ignore the laws, basically. Does that, no? Did you have a more technical question? You're not sure?
Richard Painter from Aon.
Oh, God. You put me on the spot there, Jeremy, so I've hurriedly had to think about difficult questions. But I'm not going to ask questions, but I'm just going to make some observations. First of all, Chris, thank you for depressing me. It's that time of year, you know, winter's coming, and we're all feeling pretty miserable. And Eloise, I thought your everything that you presented is what we in the insurance business call risk management. So this is everything you do to try and prevent something from happening, and then, pardon my français, shit happens. and then you have all the consequences. So Chris told us that really insurance isn't going to help you. You're out on your own, too bad for you, which is not entirely true. On the marine side, I think, and when you get into an example that you suggested of a virus or someone taking control of a ship and driving it on the rocks, is that excluded? Is that a marine peril? Does the clause 380 apply? Arguably, yes. For the other issues of the social engineering, phishing, etc., there is insurance available. And if your organization does not have cyber insurance, I would strongly urge you to contact your broker to find cyber insurance. Now, cyber insurance will not cover the physical damage or bodily injury, but it will cover a lot of the costs that Eloise was talking about. And another little issue is what we're calling social engineering. If you haven't heard of that, that is the CEO or a supplier, the Taiwan Britannia Club members who were told to send their money somewhere else. This is known in the trade as social engineering. And you'd think, well, that's a fraud. That's covered under my crime insurance policy. Sorry, that's a voluntary giving away of money, and that's not covered under your crime insurance policy. And cyber insurance does not cover fraud. So you need to get special insurance for that. So I don't want to depress you more, but maybe a little ray of light and sunshine that comes in at the end of the day.
Thank you very much, Richard. Next you remind us to get a slide put in here with Aon contact details.
Can I just add, Jeremy, can I just add something? I think one of the things, what Richard says is right, you actually do need to look at your policies, because some policies, say a loss of hire policy, quite often requires the ship not to be working because of physical damage. Now, if your ship's not working because the system's frozen by a malware, like a ransom attack, that may well not trigger your entitlement to loss of hire because there is no physical damage. And the same applies to, let's call it, land-based policies. So, unfortunately, it is a real necessity to sit down with your broker or your insurers and look at your policies to see where the gaps are and see what you can buy, either by buying out exclusion clauses or buying those additional covers.
Another issue is that in outsourcing contracts, could be also an insurance contract, sometimes there's an exclusion for anything that relates to force majeure, act of God, and then in the description you see act of terrorism, and I'm always a bit nervous. I'm like, act of terrorism, what about a hacking? Would that fall under an act of terrorism? So I've started saying in my contracts, you know, it's hacking, anything, data security is not an act of terrorism. I want to make sure that, you know, if there's the liability cap would not be triggered.
And that's the point I was trying to make. Hacking and, say, the anonymous movement.
Yeah.
Where does it cross over?
That's
because the terrorism the definition in England is ideological, political, religious purposes. Ideological. What is ideological? Is the guy who says we don't want oil tankers going through the Arctic and hacks the system. Is that an ideological purpose? Potentially. If it is, it might flip over into terrorism. And then you're into war risk policies and exclusions, etc. And on the contractual side, absolutely right. You've got to look, because the bigger the contract, the more likely there is to be something sneaky in there.
Yeah.
Well, this just goes to prove my theory that when looking at insurance, who cares what the coverage is? Read the exclusion clauses.
I've got Jeremy. I've got one question. If there's nobody else.
Peter, go ahead.
If I can, it's actually it may be for Chris, because I'm very curious on how the insurance market is dealing with a developing phenomenon being e-navigation, and e-navigation has been around for a number of years. It's finally getting some traction. I think the IMO is going to be coming out very shortly with guidelines to develop protocols for e-navigation systems. And we're not talking about enhanced navigation. We're not talking about better ECDISs and better VDRs. We're really talking about how those ECDISs and how those systems actually speak to each other, ship to ship, ship to shore, how whether through AIS, through some other systems, the ships are actually speaking to the traffic control center going through certain waters. And we're seeing the ideas being driven by some of the countries, Korea's, because I think some of the countries are seeing this as a security, rather as a safety issue, that if you are able to have the ships in your waters speak to each other and have a ship that is maybe 5 hours ahead of another ship, sending information which would in real time enhance and bring up to date the voyage plan on the ship behind her. That can do wonders with respect to reducing the risk of casualties and so on. So we're seeing that development. We're seeing it in Korea. We're seeing it in Sweden as well, where the port authority is developing these systems. But what that does is, and the point you made, which I found interesting because I hadn't really thought about it that far, it does open more doors for people to get into your system. You're no longer a closed system. So if we are moving down that road, and I just can't see us going back now that even the IMO's sunk their teeth into this issue, the risks that are being excluded under some of the policies are still risks, and those risks have to find a home somewhere. And as we've seen with a similar type of new risks that do fall under exclusions, at least initially, the market finds a way to either bring up a new product, which later on is absorbed into what may be a P&I policy. Now, is the answer going forward, and the risks are just being enhanced, and there's going to be more and more of these situations going forward, is the answer, do you think, always going to be exclusion? Or would the answer be something as simple as, you know what, as our old partner John Scott, God rest his soul, used to say, there's no such thing as an uninsurable risk. It's only a question of premium. Is it a question as simply, putting an AP on it? Or, for example, and I know this is somewhat anathema to the clubs, capping the cover.
Time's almost up.
All right. So are those the two solutions?
I will try and answer briefly. I mean, I think at the moment, I think exclusions will be the way forward in the short term because the underwriters who are writing, let's say, the marine risks, don't understand where the liability lies and what is the extent of that liability on the cyber element. And therefore, I think there is going to be a stronger and stronger cyber market which will have to price itself based upon the perceived cyber risk. The P&I clubs don't have a cyber exclusion. Why? Because our reinsurers don't have it. But once, if you get a $500 million cyber claim, I'm fairly sure that the international group reinsurers will think, I think we might slip 380 into the group contract. Because the market is scared. Because who really understands where the liability ends? As I said, you load a virus in and you turn off the Quebec or Montréal power grid. What are the liabilities when the power goes down? When the power failure in New York happened, 15, 20 years ago, what was the biggest consequence? 9 months later, there was a birth rate increase, because when the power goes out, what do you do? But can you sue on that basis? We don't know, and I think that's what an underwriter likes to know and understand his risk. So I think exclusions will be there. If you're lucky, you can buy out some of them, but for the general liabilities, I think it'd be a specialist market.